Village incident, one of the 12 main incidents referred to earlier. The office also let it be known that there will be additional courts-martial if further incriminating evidence is brought up by the Independent Commission of Inquiry. The ICOE is an independent special investigation procedure established for Rakhine allegations by the President of Myanmar, chaired by a former Deputy Minister from the Philippines, with 3 other members, including a former Undersecretary General of the United Nations from Japan. On 26 November 2019, this commission announced that it had taken about 1,500 witness statements from all affected groups in Rakhine, and that it has interviewed 29 military personnel who were deployed to the affected townships in northern Rakhine during the military operations from 25th August 2017 to 5th September 2017, as well as 20 police personnel who were stationed at the police posts that were attacked on 25th August 2017. There is currently no other fact-finding body in the world that has garnered relevant first-hand information on what occurred in Rakhine in 2017 to the same extent as the Independent Commission of Inquiry and the Office of the Judge Advocate General in Myanmar. This fact reinforces my sense that I should refrain from any action or statement that could undermine the integrity of these ongoing criminal justice processes in Myanmar. They must be allowed to run their course. It is never easy for armed forces to recognize self-interest in accountability for their members and to implement a will to accountability through actual investigations and prosecutions. I respectfully invite the members of the court to consider for a moment the record of other countries. This is a common challenge even in resource-rich countries. Recent cases in the news headlines illustrate that even when military justice works, there can be reversals. This can also happen in Myanmar. As part of the overall efforts of the Myanmar government to provide justice, a court-martial found that 10 Muslim men had been summarily executed in Indian Village, one of the 12 locations of serious incidents referred to earlier. It sentenced 4 officers and 3 soldiers, each to 10 years in prison with hard labor. After serving a part of their sentences, they were given a military pardon. Many of us in Myanmar were unhappy with this pardon. Other cases are undertaken without controversy. For example, in the Mansi case, a court-martial sat close to the location in Kachin State where 3 internally displaced civilians had been killed. It sentenced 6 soldiers, each to 10 years in prison, in January 2018. Relatives of the victims and local civil society representatives were invited to the proceedings. The Office of the Judge Advocate General in Myanmar is, by our standards, well-resourced, with more than 90 staff and a presence in all regional commands throughout the country. I'm encouraged by the Gutabiem court-martial, and I expect the office to continue its investigations and prosecutions based on reliable evidence gathered in Rakhine and from persons who witnessed what happened there. Can there be genocidal intent on the part of a state that actively investigates, prosecutes, and punishes soldiers and officers who are accused of wrongdoing? Although the focus here is on members of the military, I can assure you that appropriate action will also be taken against civilian offenders in line with due process. There will be no tolerance of human rights violations in the Rakhine or elsewhere in Myanmar. Mr. President, there are those who wish to externalize accountability for alleged war by the Gambia, have even suggested that there cannot be accountability through Myanmar's military justice system. This not only contradicts Article 20B of the Constitution of Myanmar, it undercuts painstaking domestic efforts relevant to the establishing of cooperation between the military and the civilian government in Myanmar in the context of a constitution that needs to be amended to complete the process of democratization. That process is now underway at the Phirangzu Hluttaw, the Union Parliament. The emerging system of international criminal justice rests on the principle of complementarity. Accountability through domestic criminal justice is the norm. Only if domestic accountability fails may international justice come into play. It would be inconsistent with complementarity to require that domestic criminal justice should proceed much faster than international criminal justice. A rush to externalize accountability may undermine professionals in domestic criminal justice agencies. What does the appearance of competition between domestic and international accountability do to the public's trust in the intentions of impatient international actors? No stone should be left unturned to make domestic accountability work. It would not be helpful for the international legal order if the impression takes hold that only resource-rich countries can conduct adequate domestic investigations and prosecutions, and that the domestic justice of countries still striving to cope with the burden of unhappy legacies and present challenges cannot be made good enough. The Gambia will also understand this challenge with which they too are confronted. Mr. President and members of the Court, these reflections are relevant to the present hearing because the applicant has brought a case based on the Genocide Convention. We are, however, dealing with an internal armed conflict started by coordinated and comprehensive attacks by the Arakan Rohingya Salvation Army, ARSA, to which Myanmar's defense services responded. Tragically, this armed conflict led to the exodus of several 100,000 Muslims from the 3 northernmost townships of Rakhine into Bangladesh, just as the armed conflict in Croatia, with which the court had to deal, led to the massive exodus of, first, ethnic Croats and later ethnic Serbs. As I've already stated, if war crimes have been committed by members of Myanmar's defense services, they will be prosecuted through our military justice system in accordance with Myanmar's constitution. It is a matter for the competent criminal justice authorities to assess whether, for example, there had been inadequate distinction between civilians and ARSA fighters, disproportionate use of force, violations of human rights, failure to prevent plundering of property or destruction, or acts of forcible displacement of civilians. Such conduct, if proven, could be relevant under international humanitarian law or human rights conventions, but not under the 1948 Genocide Convention, for reasons on which Professor William Schabas will elaborate in a moment. Mr. President, allow me to share one further reflection in this great hall of justice. International law may well be our only global value system, and international justice a practice that affirms our common values. Leaders of states and relevant intergovernmental and non-governmental organizations should also be cognizant of their responsibility to express and affirm fundamental values. Feeding the flames of an extreme polarization in the context of Rakhine, for example, can harm the values of peace and harmony in Myanmar. Aggravating the wounds of conflict can undermine unity in Rakhine. Hate narratives are not simply confined to hate speech. Language that contributes to extreme polarization also amounts to hate narratives. Several international actors face a challenge here. But Myanmar also could have done more since the 1980s to emphasize the shared heritage and deeper layers of unity among the diverse peoples of our country. Cycles of intercommunal violence in Rakhine, going back to the 1940s, should be countered not just by practical measures aimed at sustainable development and rule of law, but also by nourishing a spiritual mindset of unity. It is a moral responsibility of leaders to guard the aspirations of people for harmony and peace. U Thant, the third United Nations Secretary General, had understood this. He wrote in his memoirs, View from the UN, published in 1974, "I even believe that the mark of the truly educated and imaginative person facing the 21st century is that he feels himself to be a planetary citizen." Encouraging this added layer of identity, a sense of planetary citizenship, is of fundamental importance for peaceful relations between nations, as well as between ethnic and religious groups. A commitment to broadening the mindset must go hand in hand with practical steps to improve lives. Even before the events of 2016 to 2017, Muslim, Buddhist, and other communities in Rakhine faced what the Kofi Annan Advisory Commission described as complex challenges of low development and poverty rooted in enduring social conflict between the communities. The Myanmar government is committed to addressing these challenges. Together with our partners, we are now striving to ensure that all communities enjoy the same fundamental rights. To expedite citizenship verification and application, a mobile team is already in operation. All children born in Rakhine, regardless of religious background, are issued with birth certificates. Arrangements have been made to enable more Muslim youth to attend classes at universities across Myanmar. With the support of international and local partners, scholarships will also be made available to students from all communities living in Rakhine. The government has started a social cohesion model project in Maungdaw Township to promote social harmony among all communities. Interfaith fora have been encouraged. These are some of the steps taken to improve livelihoods, security, access to education and health, citizenship, and social cohesion for all communities in Rakhine. 3 IDP camps have already been closed, and an IDP camp closure strategy has been adopted. Myanmar is also committed to the voluntary, safe, and dignified repatriation of displaced persons from Rakhine under the framework agreement reached between Bangladesh and Myanmar. Mr. President, how can there be an ongoing genocide or genocidal intent when these concrete steps are being taken in Rakhine? To conclude, Mr. President and members of the court, Rakhine today suffers an internal armed conflict between the Buddhist Arakan Army and Myanmar's defense services. Muslims are not a party to this conflict, but may, like other civilians in the conflict area, be affected by security measures that are in place. We pray the court to refrain from taking any action that might aggravate the ongoing conflict, and armed conflict, and peace and security in Rakhine. Right now, in northern Rakhine, an army base near Palewa is under attack by a group of more than 400 Arakan army fighters, and some 200 insurgents have surrounded a military column near An City in Rakhine. Since Myanmar gained independence in 1948, our people have not known the security of sustainable development that is a fruit of peace and prosperity. Our greatest challenge is to address the roots of distrust and fear, prejudice and hate that undermine the foundations of our union. We shall adhere steadfastly to our commitment to nonviolence, human rights, national reconciliation, and rule of law as we go forward to build the democratic federal union to which our people have aspired for generations past. We look to justice as a champion of the reconciliation and harmony that will assure the security and rights of all peoples. Mr. President and members of the court, I thank you for your kind attention, and I ask that you now call upon Professor William Schabas to continue the Myanmar submissions.
I thank the agency of Myanmar for her statement. I now invite Professor Schabas to take the floor. You have the floor.
Thank you very much, Mr. President. Mr. President, Your Excellencies, it's an honor to appear before the court today. Our hearing today does not concern the merits of the claim that the Gambia seeks to bring. It is confined to whether the court should indicate provisional measures. It's established case law that certain preconditions must be met if the court is to do so. My presentation will focus on the requirement of a plausible claim. I will be followed by Mr. Staker, who will speak to the requirements of prima facie jurisdiction and standing, and then by Ms. Okawa, who will complete our first round of observations by addressing the lack of real and imminent risk of irreparable prejudice to the rights in dispute. The Gambia seems to accept the plausibility test developed in the court's jurisprudence, but has misunderstood the standard applied by the court. The plausibility requirement is a necessary corollary of the mandatory nature of the court's provisional measures. For this reason, the references to provisional measures orders in 1993 may not be as helpful to the court as the Gambia suggested yesterday, given that they were adopted well prior to the court's important ruling on binding provisional measures in the Legrand case. The Gambia claims that the rights it alleges are plausible, provided they are based on a mere, and I quote, possible interpretation of the convention. Mr. Presidency, Your Excellencies, twice in the past 12 years, this court issued judgments on the application of the Genocide Convention. It has examined in excruciating detail both the material and the psychological elements of the crime, applying well-accepted principles of interpretation, studying the travaux préparatoires, and showing due deference for specialized bodies like the International Criminal Tribunals for Rwanda and the former Yugoslavia. Interpretations of the convention that may have been plausible in 2006, before the judgment in Bosnia and Herzegovina versus Serbia, have ceased to be plausible since then. And if there was any doubt, the court's judgment in Croatia versus Serbia in 2015 resoundingly confirmed what it had said in 2007. Yesterday, counsel for the applicant avoided discussing the impact of these recent judgments. There were several references to the 1951 advisory opinion, but apparently none to the 2015 judgment. In discussing the interpretation of Article 2 of the 1948 Convention, rather than turn to the court's recent pronouncements, counsel cited Raphael Lemkin's famous book published in 1944. In the sentence that was cited, Lemkin said that the focus of genocide was not on, quote, the immediate destruction of a group, but rather with destruction of the essential foundations of the life of national groups. Alas, Lemkin's original vision, which had much in common with our modern conception of crimes against humanity, did not prevail in the General Assembly in 1948 when the convention was adopted. The drafters of the convention settled on a much narrower view of the scope of genocide than Lemkin had contemplated in his book, and one that has since been confirmed in the case law of this court. It was only on the basis of this narrower conception of the crime of genocide that states were willing to accept and undertake significant obligations, including the compromissory clause. Indeed, more than 70 years later, they still hesitate to adopt a comprehensive, equivalent convention dealing with crimes against humanity, despite noble efforts of the International Law Commission. Here we are, 4 years after Croatia versus Serbia, and the court is being asked to indicate provisional measures based upon allegations that simply cannot meet the terms of the convention as authoritatively interpreted by the court. In Croatia versus Serbia, the court described a distinction between ethnic cleansing and genocide, with the former implying displacement and the latter referring to destruction as, and I've highlighted the words on the screen, solidly rooted in its jurisprudence. The authority of that judgment is surely enhanced by the size of the majority, 15-2. In Bosnia, the majorities varied for each paragraph of the positive were between 11 and 14. Unless the court were now suddenly and abruptly to abandon its jurisprudence constante, the Gambia, based upon the facts alleged in the application, does not have a plausible case, a case with any possibility of success. Members of the court may recall that in the Croatia versus Serbia case, Croatia invited the court to reinterpret the convention provisions. You were told, and I quote counsel for Croatia, that, and I quote, the law has moved on over the past 7 years. The quotation is on the screen. If this case ever gets to the merits stage, I expect you will hear similar statements, proposing once again a break with your established case law. Is this plausible? Does this mean that any claim before the court that is inconsistent with established case law is plausible because, to return to the phrase in the application, it consists of a possible interpretation of the Genocide Convention? Can a challenge to something that is solidly rooted, those are the words of the court, in its jurisprudence have a plausible chance of success? Mr. President, Your Excellencies, the plausibility criterion first appeared in the case law of the court a decade ago in Belgium versus Senegal, a case involving no evidentiary issues. Subsequently, Judge Greenwood wrote that the court might just as well have opted for the term arguable, more widely used in common law jurisdictions. He said, and I quote, unless there is a reasonable prospect that a party will succeed in establishing that it has the right which it claims and that the right is applicable to the case, then it cannot be said that the right might be adjudged to belong to it. Over the years, of course, the court has become more demanding. In recent cases, it has held that both the legal arguments and the evidence presented must be plausible. In Ukraine versus Russia, rejecting a request for provisional measures under the International Convention for the Suppression of the Financing of Terrorism, the court stressed that the applicant had to, quote, afford a sufficient basis to find it plausible, and that the constitutive elements of knowledge and intention required by the convention were present. The court found that there was no sufficient evidentiary basis to find it plausible that such elements of intention and knowledge were indeed present. The rejection of provisional measures in Ukraine versus Russia is especially pertinent because it involved a treaty of international criminal law, a cousin of the Genocide Convention, as it were. Subjective intent and knowledge are, of course, also requirements of the Genocide Convention. Thus, for the purposes of provisional measures, a plausible claim under the Genocide Convention must include evidence of the required specific genocidal intent. For it is this subjective intent that is the critical element distinguishing genocide from other violations of international law, such as crimes against humanity and war crimes, for which, in this case, the court obviously lacks jurisdiction. Furthermore, Mr. President, Your Excellencies, in assessing whether the required level of plausibility is met in relation to both legal and factual matters, the court should also take into account the gravity of the alleged violations. The court's well-established approach at the merits stage is that the graver the charge, the more confidence must there be in the evidence relied on. This principle must apply mutatis mutandis at the provisional measures phase, which may also result in a binding decision. Indeed, it must apply a fortiori, because the court is not able to hear full argument, with the respondent, unlike the applicant, unable to fully develop its own evidentiary base. In a case like this, involving allegations of exceptional gravity, a correspondingly stricter plausibility standard should be applied already at this phase of the proceedings. Mr. President, Your Excellencies, in Bosnia and Herzegovina versus Serbia and Croatia versus Serbia, the court did not have much difficulty concluding that some of the underlying acts listed in the paragraphs of Article 2 of the Genocide Convention had been established. I do not propose to consume any time here this morning arguing about this point. Let us assume, without making any admission for Myanmar, that a plausible case can be made for the application of at least one of the paragraphs of Article 2 of the Convention. Much time was consumed at yesterday's hearing with the recital of what we can all read in the reports of the fact-finding mission, and this despite your reminder, Mr. President, of Practice Direction 11. The hard part, and it was on this that both the applications and the counterclaim floundered in the two genocide cases decided recently by this court, is the mental element. And on this point, the applicant has had little to say other than the mistaken assumption that a pattern of conduct is enough to constitute a plausible claim. The United Nations fact-finding mission, upon which the application relies so heavily, frequently refers to the inference of genocidal intent. The theory seems to be that certain types of acts, taken individually or as a whole, tip the balance in favor of a conclusion that they were committed with genocidal intent. With respect, that's not what this court said in the Bosnia and in the Croatia cases. The real test, and the court has repeated it on several occasions, is not that genocidal intent be a possible inference. Let me use the language of provisional measures. It's not that genocidal intent should be a plausible inference. The court has said it is necessary, quote, that this is the only inference that could reasonably be drawn from the acts in question. Addressing the counterclaim in Croatia versus Serbia, the court said that for a pattern of conduct, that is to say a consistent series of acts carried out over a specific period of time, to be accepted as evidence of genocidal intent, I've highlighted the words on the screen, it would have to be such that it could only point to the existence of such intent. That is to say, that it can only reasonably be understood as reflecting that intent. In declaring that genocidal intent must be the only inference that can reasonably be drawn from the acts in question, this court has brought great clarity to the law. Instead of focusing on whether genocidal intent is plausible, it looks in the other direction. Is there another explanation? There's an enormous amount of unproductive speculation about genocide. It's often prefaced with phrases like, if certain things were proven, it might even be genocide. And indeed, given the prevalence in the world of today of racial and religious discrimination, of apartheid-like policies, and of persecution of ethnic minorities, indigenous peoples, migrant workers, and refugees, in many countries and conflicts, the acts that may fit within the paragraphs of Article 2 of the Convention and about which it can be said, if certain things were established, this might amount to genocide. By insisting that genocidal intent, if based on a pattern of conduct, be the only reasonable inference, the court has developed an